Good afternoon, distinguished panelists, colleagues, and delegates. My name is Tobenna Erojikwe, and it's my pleasure to speak to you this afternoon. Unfortunately, I'm on the road, so I can't put on my camera. But nevertheless, it's a pleasure to welcome you to this session of the MBA ICLE training series on debt recovery and asset tracing. Just to very quickly express my gratitude to the coordinators of the training, Kubi Dofia and Ozioma Ago, and to all the panelists who have kindly agreed to support this initiative. Of course, we're starting with the best today, and I will let Kubi Udofia do the honors of introducing my friend and one of the most passionate promoters of legal education and continuing legal education in Nigeria, Mrs. Boma Alabi, Senior Advocate of Nigeria. I'm very grateful to you, Leonard, for finding the time to join us and indeed to kickstart this training series. Thank you very much. I will now yield the floor to Kubi so that he does the honors. Kubi.
Thank you very much. Good afternoon, Leonard Silks and colleagues. So without boring you further, please permit me to go through the citation of our facilitator and speaker today. So Ms. Boma Alabi, Officer of the Order of Niger and Senior Advocate of Nigeria, she's a senior partner with Primera Africa Legal, PAL, and leads PAL's regulatory compliance and dispute resolution teams. So in addition to being an experienced arbitrator and accredited civil and commercial mediator, she's experienced in international tax law, maritime law, mergers and acquisitions, and capital market transactions. She has advised on some of Nigeria's leading commercial deals in a number of sections or sectors, including the real estate and infrastructure, manufacturing, banking, hospitality, telecommunications, maritime, energy, project funding, and development. Boma served as the president of the Commonwealth Lawyers Association between 2011 and 2013, the first and only woman president in the over 60-year history of lawyers from 54 countries across of the Royal Commonwealth Society, and also served as the chairwoman of the Association of Women Solicitors of England and Wales between 2005 and 2006. She's a member of the Institute of Directors and the International Chamber of Commerce. She serves on the board of Alpha International Organization with headquarters in Chicago, and as chairman of the Shippers Association of Nigeria, as well as the chairman of Shipping Lines Operators and Freight Forwarders Employers Association of Nigeria. In addition, Boma serves as an independent non-executive director on the board of ARM Harris, Cowrie Asset Management, and Whisker, a not-for-profit structured mentoring organization. Ladies and gentlemen, you would agree with me that our facilitator today is exceptionally experienced and knowledgeable. But before I yield the floor to our facilitators, by way of housekeeping, our facilitator would have about an hour to deliver our paper and speak to us. And I appeal to all of us to keep our gunpowders dry. If you look on your screen, you see the Q&A tab. If you have questions, in order not to lose your line of thought, you can post your questions there. We'd have about 30 to 40 minutes to take as much questions as possible as time would permit. So I guess that's all for timekeeping and or housekeeping. So ladies and gentlemen, without much ado, I want to at this point yield the floor to Ms. Boma Alabi, OON Senior Advocate of Nigeria. Leonard Silk, you have the floor.
Dr. Kubi Udofia, I thank you very much for that kind introduction. And also to Benda Rojikwe, my friend, for really running with the ICLE on behalf of the Nigerian Bar Association and organizing these great training sessions, all as part of our membership benefit of the profession at no charge to us. So thank you all very much. I also want to encourage those of us who are already here to please note the fact that this is a series of trainings, and it's today, it's tomorrow, it's literally 7 days. And you would benefit greatly from each and every one of these sessions. I am very much looking forward to the ones coming after me, because they are going to be far more technical than this starting session. So I was given the topic, effective and efficient legal strategies for dealing with debt recovery instructions. And as usual, I tend to try and work in a way that is as practical as possible, because we're practitioners. I don't want us to deal with academic issues. So without further ado, I'm going to start off with, I have a small slide for you. I will be speaking mostly to that slide. It's really just to give you some background information. So some very basic information, which you probably all know. It's very difficult to tailor training when you don't know your audience. So if it's very basic and I'm teaching my grandmother to suck eggs, do forgive me. Following which, we'll then go on to some case study scenarios, which are taken from our practical cases that we've dealt with. And we will use that to talk through the step-by-step guide to dealing with recovery instructions. And that's the plan for this workshop today. So I have to give credit to my junior who worked with me on this. And you will see that the presentation is between Jacinta Okoro Esquire and myself. So let's start with debt recovery. What is that? It's the process of pursuing payments of debts owed by individuals or businesses to other businesses, to a creditor or a lender. It involves a systematic effort to recover outstanding balances or other financial obligations that have not been repaid within the agreed upon time and terms. So debt recovery process, the process would typically start with reminders or notifications sent to the debtor, urging them to meet their payment obligation. The way we tend to do things these days, you find, and this is before you bring the legal practitioner in, the reminders might be happening via telephone calls, WhatsApp messages. Very rarely do they send out letters, sometimes via emails. And if these initial attempts fail to secure payment, then more aggressive collection methods are utilized, sometimes to the point of then appointing a collection agency or legal representatives to pursue the debt and recover it. So in some, as I've just said, in some cases, the creditors may resort to legal action to compel the debtors to repay their debts. And our action can then lead to a judgment against the debtor, which may result in garnishing of wages and entitlements in order to satisfy the debt or selling off assets, depending on what collateral was provided. So I'll give you an example of circumstances where you can garnish wages and entitlements. For example, a lot of employees in stable workspaces and working for companies like, I'll use an MTN, for example, but the blue chip institutional employers, you'll find are very attractive borrowers to the banks. So the banks will happily offer them credit against their wages, against their monthly emoluments, so to speak. And they would require the employer to effectively undertake that the wages and the entitlements will be paid to them via a dedicated account or a designated account with that bank. So they get first call on employees' wages and entitlements. Now, that's the bank because they get legal advice ahead of time and they think ahead. But where you have a debtor who is not in that position, then you're going to be looking for a garnishee of wages and entitlements from the courts. Now, debt recovery is essential for businesses and financial institutions to maintain liquidity. Without liquidity, no business can survive. Cash flow is literally the lifeblood of businesses. So they've got to find the balance between recovering their outstanding debts, maintaining a positive relationship with their debtors or customers, and at the same time, ensuring that that cash flow continues to flow. In Nigeria, we have challenges because I have experience in 2 jurisdictions, and it is so much easier to collect debt in England than here, simply because once you're owing beyond a set out time, which is a statutory time frame, and obviously in breach of your agreement, then you can literally start winding up proceedings because that company effectively is not solvent if it's unable to meet its financial obligations. That's really a big stick, but a stick wielded that can quickly get repayment or a payment plan in place and keep them in line to make those repayments to the creditor. But in Nigeria, debt recovery entails making legal demands before considering the possibility of taking action. If there is a mediation or arbitration clause in the agreement that out of which that debt arises, then obviously that has to be given priority. Because if you attempt to go for litigation without exhausting the ADR option, that in itself will be a cause of delay in your debt collection process, because they would simply raise that as an objection, so to speak. Can we go on to the next page of the slide, please? Dr. Kubi, can we go on to the next page of the slide, please? Can you go on to the next page of the slide, please?
Are we on page 2? Okay, I think what I'll do is I'll stop sharing for the MBA administrator to share, because I think my network is a bit slow.
Okay.
Okay. So Sarah, please, can you share from your end?
Okay, whilst we're waiting for Sarah to do that, I will carry on. Again, it's so important that the parties agree a procedure prior to transacting. Unfortunately, the reality is in a lot of transactions, they do not consult us until there's an issue. But if the opportunity is there, it can't be overemphasized that an agreement should always be drafted when parties are getting to any form of contract, especially when it involves payment from one to the other. The parties may include clauses on the methodology for collection of any obligation or resulting debt owed to another party. Also, they should include clauses on methodology or for enforcement or recovery in the event of breach by either party. They may resort to using the procedure they've chosen to follow under the agreement, which may include arbitration or any other ADR mechanism. They may also resort to use the neutral third party in resolving the issues if it's stipulated in the agreement. Now, it's the courts that when we go to litigation, it's obviously the courts that have the power to hear and determine an action for debt recovery and enforce payment against a recalcitrant debtor. That's again where we come in. So a lawyer acting on behalf of the creditor will commence a debt recovery action and possibly claim damages for breach of contract. We have 36 states in Nigeria. I'm stating the obvious, but why is this important? We have different practice directions and different rules in the different states. So I'm not going to drill down to each and every one of those because time will not permit us to do that. But I would simply say, whichever jurisdiction within the country you're working from, you would look at what your rules say and ensure that you're following those rules. Invariably, it always starts with a demand because you have to have given them an opportunity to make that payment before you approach the courts. So there has to be a letter before action, generally speaking, and a timeline within which you've asked them to make the payment and they have then failed to do so. So my colleague quotes the case of Hung versus EC Invest and Co. Nigeria Limited, where it was held that in a claim for recovery of a debt, and the citation will be provided to the MBA support team after this. In a claim for recovery of a debt, the cause of action accrues when a demand is made and the debtor refuses to pay. So what that simply says is, if you haven't made a demand, then even where they are in breach of the agreement, you're not in a position to approach the courts as yet. Now, I would go so far as to say that if the demands have been made by the creditor prior to instructing you as a lawyer, you still have a duty, so to speak, to then write to the debtor, demanding the funds owed and warning about the consequences if payment is not received on or before a stipulated date. That letter of demand serves as your pre-action notice for a debt recovery proceeding in some jurisdictions. In others, you still have to then send out another one specifically titled the pre-action notice prior to taking the matter further as a claim before the court. So can we go on to your next slide, please? I believe you're into the slide 5 now. Sarah, are you on slide 5? I can't see your slides.
Yes, I'm on slide 5.
Am I the only one having, because I see Dr. Kubi Odofia has started screen sharing. I don't see Sarah's slides at all. Let me see what the comments are, if this is a challenge for others too. Can someone from the audience confirm if they can actually see the slides?
Can you see it, ma, now?
So I can't see it from here. I can't.
You can't see it from your end, right?
Yes. So it's interesting because some of the comments that are coming in,
Okay, good afternoon.
some say they can't.
Excellent. We're there now. Thank you, Sarah. So some of the techniques that are utilized in debt collection, certainly not by us, legal practitioners, but generally speaking, you might have, in the heydays of AMCON, seen that they were publishing names in newspapers and as a pressure point to get bad debtors to meet their obligations. So this method is used by companies to recover their debts. It has its merits, obviously, because some debtors do care about their reputation and will want to avoid that reputational damage if they can. Others use debt collectors rather than coming to us, the lawyers. And of course, we all know that it is common practice now in Nigeria, sadly so, to arrest and detain debtors until they can pay off their debts by getting security agencies involved, either by alleging fraud or other criminal behavior that will then bring the transaction within the jurisdiction of the law enforcement agencies. But if in this case you're acting for the debtor, even if the debtor is a company, the owner cannot be arrested and held in detention because a debt has not been settled. There's an old saying that, a debtor doesn't go to jail. And that should be the case where there is no criminal element to the debt. But like I said, it has become a lucrative sidekick for law enforcement agencies. And sadly, because of the delay in our courts and the time it takes to pursue a claim from beginning to end, this is becoming a preferred option for quite a number of creditors. Shall we go on to the next slide? Sarah? Next slide, Sarah. Okay, well, we talk about options to the creditor on the next slide. And I'm going to proceed because we're almost 30 minutes into this presentation and I still haven't got to my scenarios, which is the interesting bit. So banks and other lending entities often demand collateral. We have, you'd have heard the comedians and others talk about the fact that, before you can get a loan from the bank, they will ask you for your grandmother's grave, your father's birth certificate, and so on. So yes, our banks here tend to require quite a bit of collateral before they will approve a loan. And they can call in or realize this security once the borrower defaults on the loan. So the bank can sell the collateral to recover their money. In some cases, the borrowers may try to delay the sale of their collateral by filing frivolous legal actions and obtaining injunctions. This strategy can be particularly difficult to counter in rural or semi-urban areas because it might be challenging to find buyers for the property if it's a property that's used as collateral, which is why, again, in practice, you find that most of our banks will not accept collateral these days outside of the major sort of capital cities of the states. Now, going on to debt recovery through the use of legal practitioners and the court process. As I earlier on said, it's now seen as a last resort when creditors have tried every other method to recover their debts, but have been unsuccessful. And this is sadly because of the delays in our justice system, which we have to take some responsibility for it, because the number of times I find colleagues filing frivolous applications because they know they haven't got a good case and they just deliberately want to delay. The number of times just sheer lack of there are errors in our processes, and then we have to refile and we have to refile and so on. So all of those are avoidable causes of delay to the process that in turn erodes confidence in the justice system. And in so doing, means that less work is coming to us as lawyers in this area. It has been suggested that special courts should be set up to handle debt recovery cases due to the adverse effect of huge debts being owed to commercial concerns and the delays not helping matters whilst the assets are dissipated. Now, AMCON practice directions are a good example of such a measure, but we know that delays still occur due to a number of reasons. Shall we go on to the next slide? Slide 7, please. Now, it's important to recall and remember, and I know, like I said earlier, it's a bit difficult to gauge the level of experience of my audience. So if we're going over some pretty simple, basic stuff, it's still important that we remember it. Limitation to an action for a debt recovery, it's important to bear in mind that it will be statute barred if it's not brought on time. I believe the general time frame is 6 years across the board. This means that the law will not allow an action against the debtor if such action is not brought to court within the span of 6 years from the day in which the cause of action arose. Now, the 6 years begins to run from when the cause of action arose, not necessarily from the start of the agreement, or when things were going well between the parties. So in concluding this aspect of the workshop on the basic principles, please note again that self-help is not advisable. And so if a client comes and wants to proffer that as a possible solution, let them know that as legal practitioners, we cannot be a part of such measures, using threats, destruction of the debtor's goods or property, or using the police to arrest and detain and harass the debtor. Simply not advisable, not acceptable, not something we should participate in as legal practitioners. Okay, now we've got that basic background out of the way. Let's get to the exciting part of this. I am giving you live examples of some of the cases that we've dealt with, and then I'm going to talk through step by step what we would do in this situation. So scenario one, your client paid 70% of the purchase price for a 3-bedroom flat in a block of 20 flats in Lekki. At the time this payment was made, it was off plan, which means that the construction hadn't started. It was a plan that was shown to the individual. Obviously, the developer could show that it acquired the land and all of that, and had funds, and were also going to use some of the funds from the buyer to construct the block of flats. So on that basis, the client paid 70%. The developer promised to complete construction by 2018, which was 2 years from when this payment was made, but was nowhere near completion by 2020. And the COVID-19 pandemic shut down. When that shutdown happened, with the government restrictions, obviously the site was shut down, workers went home. After the government restrictions were lifted, work did not commence. Thus, the project remained uncompleted. To compound his default, the developer had also sold the flats to more than one buyer, including the flat your client had paid 70% down payment on. Your client wants his money back, as he has lost all confidence in the developer. What would we do with this situation? So, step one, the scenario I'm just giving you is your client's instructions. This is his story, because I find that some of the younger lawyers, when you talk about a client's instructions, mistake that to mean that we take instructions from the client and we do as we're told. Please, that is not the case. Our role is to advise the client based on our knowledge of the law. When we talk about taking instructions, we're simply asking the client for the facts. So give us a synopsis of the facts. And that's what we mean by client's instructions. So the first step would be taking the client's instructions. From the instructions, you will distill a scope of work. So that scope of work would come out of your strategy for recovery. All of this is important at the onset because in line with our legal practitioners remuneration order 2023, we all now must issue a letter of engagement to the client. And what I'm talking through now is what our typical letter of engagement would typically contain. So instructions, the facts, then we apply the law to those facts and come up with a strategy which will help us define the scope of work that we're going to be delivering to the client. We then look at the fees we'll be charging because, again, in line with best practice and our legal practitioners remuneration order, we have to inform the client as to the fees that they're expected to pay and ensure that we do not undercharge them. So if we go to the LPRO, I'll shorten it to that, 2023, there are specifics as to what we can charge in relation to certain types of work. And that's consultation for legal opinion, incorporation or registration of companies, litigation, which is generic, and property transactions. But in this case, the strategy was not necessarily to begin with litigation, and therefore the remuneration would fall under Legal Practitioners Remuneration Order 2023, I would say clause 2, where it talks about remuneration with respect to other matters. So in considering what you would charge that client, you would look at the complexity of the matter, the difficulty or novelty of the issues in question, how much skill, labor, experience, specialized knowledge and responsibilities required from you as a legal practitioner, the number, diversity, technicality, and importance of the documents to be prepared or perused, the time you would expend on the service, on the transaction, on the debt recovery, location and circumstances in which the business or service or part of it is transacted or performed, the turnaround time required by a client for completion of the business, amount of money or value of the property involved, and the importance attached to the business by the client. So this is what our Legal Practitioners Remuneration Order 2023 says we ought to consider in looking at the fees to be charged. And then I would also say, if you're in a practice of more than 1, 2, 3, 4, 5 working together, you should also detail who has primary responsibility for the work and the timeline within which you will deliver it. Now, that's an important first step in dealing with debt collection from a practitioner's perspective. Once you've got that letter of engagement set out, it gives you clarity as to what you intend to do and how you're going to do it, because you've had to think through your debt collection transaction really from the beginning to the end. Now, in this case, we looked at what where's the value? And how quickly can we extract that value and get our clients' money back? From experience, we guessed that the developer would not have transferred title to the purchasers because the project remained uncompleted. And of course, we conducted due diligence at the land registry and found that, as a matter of fact, the developer had title in the name of a different entity to the entity that our client transacted with. Again, this is one of the reasons we keep saying to clients, come to the lawyers before you have a problem, not afterwards. Because if that client had approached us for legal advice prior to paying the 70% of the purchase price for a 3-bedroom flat, rather than coming to us for debt recovery, we would have conducted the due diligence at that point and ensured that payment was actually being made to the entity with the value, the entity that held the property, the title to the property, the title to the assets that the client was buying into. Unfortunately, like I said, lawyers were not consulted until things went awry, and it became extremely difficult to really do much to assist them. We did eventually get to a settlement, and that settlement happened because there was a dispute, an ADR clause in the agreement, which we triggered once we'd sent out a letter of demand to the developer. So I'm going to go on to the next scenario. Can we please move to scenario 2? So scenario 2, again, like I said, I'm taking these from real life cases that we've done, obviously moving things around a bit so that they're not to keep client confidentiality. So a Chinese company was awarded a turnkey project installation for $1.6 billion US. The contract detailed payment in 8 milestones. All works and installation were completed to 100% of the of the requirements, and not only that, marked satisfactorily completed. There was absolutely no complaints whatsoever on the delivery of service, on the timeline for delivery of service, and the fact that the work was completed. And the OwnCo, that's the owning company of the turnkey project, in turn, initially met the milestone payments promptly. So the first 4 installations, installments were paid in good time, in line with those milestone payments. Following that, the 5th installment was delayed and paid in breach, and interest began to accrue. They were served with a demand notice, and eventually, after much backward and forwarding between the two parties, payment plan was agreed, and this was drafted as an addendum to the original contract to reflect the payment schedule that the parties had agreed. Unfortunately, the OwnCo also defaulted on this You have the brief. What steps are you going to take? Again, bear in mind what we talked about in scenario 1, where you will look at, this is your facts, your instructions, you then distill your scope of work, and you look at all of those elements that I talked about from the remuneration order, and then you decide what fees to be charged. I always insert an additional clause, by the way, in my letter of engagement to see if there's this is based on the information we currently have, and if there's additional information that makes it more protracted or difficult, then we obviously reserve the right to reflect that in the fees that we're charging. So I would also commend that to all of us, because in some cases, in a lot of cases, all of the information is not available ab initio. It is as you progress that more begins to be revealed. This was actually the situation in this case. So we had an agreement for the turnkey project installation. We had the addendum, which also set out the agreed payment schedule, which the OwnCo defaulted on. And we had the client's story. So from our perspective, what steps are you going to take? Simple summary judgment, because there's the debt was not denied. It's admitted. There are no, they've confirmed that the project installation was 100% complete and completed to their satisfaction. You know, on the face of it, straightforward. Following on from that, if you get your judgment, summary judgment, you then go for garnishing proceedings and so on. However, just as we sent out the first letter before action, because we send out a demand first and give them a timeline within which to make payments, usually 14 days, that's what we do. And if that payment isn't made, and please diarize your 14 days, because again, I find lawyers, we send out the letters, we forget to diarize when the next letter is due out, as a result of which you find a month later, that's fallen off your in tray, so to speak, and you're not progressing the debt recovery transaction as promptly as you could. So if I send out a letter today, the 19th of January, I will have it in my diary 14 days from today to follow up on that letter if no response has been received. And at that point, I would then send out a pre-action notice and follow on from that, diarize again, and then begin to take the steps. Obviously, at this point, you have started drafting your processes and you're really just waiting to file when the time gets to the deadline you gave to the debtor. And then the client produces additional documents. Among those documents is another agreement between the parties, which says before, and in relation to this same project installation, before you can go to litigation, you must have an arbitration. And there's an arbitration clause there, which states that you parties are to refer to, let's say, the ICC or the Nigerian Institute of chartered arbitrators to appoint a sole arbitrator. And so that stops you right there in your tracks, because you have to go to arbitration first before litigation. And I do not mean before litigation, because hopefully arbitration will be the end of it. And once you have your award, that would be that. It's the mindset where it's okay, arbitration before litigation is a mindset we have in this jurisdiction, which should not be encouraged at all. So in this scenario, that's where we ended up. We're now in arbitration. We are asking for the hearing to be done on the documents and no need to call any witnesses, because the documents themselves will speak for themselves. And so that's where we're at. I would go on to scenario 3 very quickly. I'm conscious of the fact that I'm almost running out of time. Scenario 3. Okay. And what I'd like us to do when we go to the conversation part of this, and you can even do this right now whilst we are talking through the 3 scenarios, come up with your suggestions as to what you would do in either one of these 1, 2, 3 scenarios if your client gave you this instruction. Right, so scenario 3, your client supplied building materials to supermarkets in Port Harcourt on a sale or return basis. Again, at this stage, they're not consulting us. The supermarket was razed down by a fire due to a power surge. Supermarket owners wrote to your client with this information and assured that claims were being processed by the insurance company, and any loss to your client will be remediated in due course once the insurance claim had been honored. Now, the insurance claim has since been fully satisfied to your client's knowledge. The supermarket denies any liability to your client, as there are no records on their file to support your client's claim. So your client has now come to you to collect the debt. What would you do with this scenario? Again, this is a real life situation. What we found was very little documentation in support of the claim. And that's often the case. You find that in a lot of these transactions, there are no formal contracts, so to speak. However, it's our job to conduct due diligence. It's our job to find evidence that we can use to support the client's case from amongst the myriad of documents or stories or things they tell us. So in this case, we asked if there were any receipts. And unfortunately, there were. So at the time the building materials were dropped off, somebody received them. That gave evidence in support of the quantity and the fact that these building materials were in fact delivered to the supermarket at a certain time. As we all know, the burden of proof shifts, and it's not a criminal at the same level as for criminal matters. It's on the balance of probabilities. So if I can show that these building materials were delivered to you at a certain time, it's up to you to now show that you've actually paid me for the items that were delivered, or I think we can then come to a reasonable conclusion that they must have been raised in the fire, and your insurance payout should certainly I should be part of or a beneficiary of the insurance payout because I have been I have suffered a loss with you. So that's the approach we are taking. It's an ongoing situation. I'd be interested to hear from participants if there's more that we can do on this scenario. And yeah, or if you would have approached it differently, bearing in mind the fact that, like I said, these sorts of transactions, they're not usually, there are no underlying contracts with them. People tend to be quite casual. They have a conversation and agree things via telephone and deliver invoice. We're actually fortunate that, that was the case, proof of invoice and all of that. So there we are. And the last of the slides before we go to the last of the slides, actually, I was also asked to speak from not just from a debtor, acting for the creditor perspective, but acting for the debtor. So I'm just going to say a few words about that. And we have acted for the debtor in a situation where there was a loan to the company of 250 million naira. Again, thanks to COVID and the challenges that came with it, the company ran into difficulties and was unable to repay or service that debt. Now, fortunately, they approached us fairly early, and we advised them to immediately notify the creditor, because the earlier you notify the creditor, the better. So this is the situation. Can we renegotiate the interest payable on this loan? It's going to take us a lot longer than we expected because of these changes in the factual circumstances, which are beyond our control and totally not envisaged. And here is a realistic payment plan. So we got the business based on your current performance to work out a realistic payment plan that they can stick to and ensure that they still have sufficient liquidity to keep their business going. And with that, we're able to persuade the bank to accept that payment plan. We renegotiated the interest, and I'm glad to say that the business is sticking with it, and those payments are being made, and the business relationship is ongoing. Right, so that's speaking from the acting from the debtor's perspective. Thank you very much. Now it's time to talk. I'm looking at the comments. There's a question. Yes, go ahead. Please go ahead, Dr. Thank you
very much, Leonard Silk. Leonard Silk, can you?
I can hear you, but you're fading in and out. I'm not sure if I'm the only one who's having that.
Oh, thank you so much for doing your screen. Thank you so much. And I can see that questions pouring in torrentially, a deluge of questions. So I'll start from the last one. And the question is from Ambrose. Ambrose says, I have read English cases which say that there must be a real dispute before arbitration clause can be triggered. and a court could not recognize it and order a stay. Where in scenario 2, there appears to be no real dispute, can a party still approach the court for summary judgment rather than going to arbitration?
Good question. I wish I had this case off the top of my head, but I have notoriously poor memory. There's a case I recently read. This is a Court of Appeal case in Nigeria. And similar to this case of the scenario 2. And yet the court was of the opinion that if there's an arbitration clause, the fact that you are having to approach the court means that there is a dispute, regardless of, the fact that there's no real dispute in the sense of this is owed and you have to pay it. Nonetheless, it's not being paid, you're having to approach the court for enforcement. That is a dispute in their view, and therefore we should go to arbitration. I will make that case available to the Secretariat. It comes to mind. I just can't, I remember the facts of the case and the outcome, but I don't remember the name.
Okay, thank you very, very much, Leonard Sok. I think the very first question has been addressed by the scenarios. Said, can we have examples of recovery from instruction to end? So that has been addressed. So we look at the second one. The colleague is asking, okay, he's saying that there are instances where online microfinance banks release data of their debtors to third parties for debt recovery for purposes of recovering debts where there's a default. So he's asking whether this is a good way of recovering debt in the light of risk of defamation or data privacy infringement issues.
Well,
so practice, yes.
We would go to the agreement between them, and it's important to read the small print, particularly these online agreements. They just, you have pages and pages and pages of clauses, and invariably, most individuals do not read the entire thing. They just take the agree. And therein lies the trap, because if in that document that you've agreed to, it gives them the authority to share your information or whatever else, and invariably they do, because they will talk about their partners. If you look at it, click on those partners, you might find 600-700 different companies are listed as partners, and you're effectively given permission for them to share your data with all of these people. So the short answer is, if the agreement you have with them permits them to do this, then you're stuck with it. If it doesn't, that is where you then have rights to pursue them for your data privacy, violation of your data privacy, and so on.
Thank you, Leonard Sok. So the next question here says, I think it's from Madwago. He wants you to shed more light on the 6-year statute bar for debt recovery with respect to when time starts to count.
Okay, I will use a specific example where this is an ongoing matter as well. So the creditor, who is also a colleague, obviously knew that there was a timeline within which this debt had to be, we had to take action, otherwise it would be statute barred. But being reluctant to take action because of the relationship with the debtor, eventually had no choice. In order to protect the rights of the creditor, we then went and filed a claim. We literally wrote to the debtor about 2 or 3 weeks before the time elapsed. And that time started to run from the initial default when the creditor notified the debtor that this is, you now have to pay me back my money because you've defaulted. So it doesn't, and I hope I'm being plain English and clear enough, it doesn't start to run from when the transaction starts. It starts to run from the point of default and the notification of that default. And then once you're in court, the matter is outside of your control. And therefore, if that takes another 6, 7 years, that doesn't count. I hope that's clear enough.
Yes, it is. Thank you so much, Leonard Silk. So before we take on more questions, I think it's also imperative to see the feedback we're having from our colleagues. So I see Elizabeth Okeke here. She says, thank you, Leonard Silk, for an insightful lecture. And then there is Ota Nada from Suleja branch. She says, brilliant session so far. And then Dr. Mary Jolasimi from Port Harcourt branch says, this is very timely and brilliant. And then there is a message from Chinasanwa Bufo, Siga branch. He says, the best way to upgrade. Thank you. And then thank you, Leonard Silk, for, I think I've taken that already. So I think we still have time for a few questions. And there is one here from Momodu Aisha. Says, when a debtor chooses to utilize a debt recovery agency or consultants for debt recovery, can the consultant sue on behalf of the debtor?
Again, it depends on the terms of engagement. It is possible. It is possible. I know AMCON, for instance, at a point had consortiums effectively come together in order to assist them with their debt recovery. So the lead in that consortium may not be the law firm or the legal representatives. The agreement between AMCON and the consortium would be between the leader of the consortium, which, let's say, for example, ABC Limited. ABC Limited would then be working with estate surveyors or quantity surveyors and lawyers, and would have the authority of the creditor, it may be in AMCON at the time, to instruct lawyers to take the necessary steps if the debtor remains recalcitrant and they're unable to recover the debt without recourse to the courts. So it is possible, but it depends on the terms of engagement.
Thank you very much, Leonard Silk. I think I saw something on that. Okay, so Abiola here asks, what other options are available to a creditor to recover a debt where garnishee proceedings have been explored, but the debt has not been fully settled?
Abiola, I would actually take a step back, because at the point before we get judgment is where we want to ensure that all the assets that are available have been verified and put before the court, so that we can garnishee every possible asset that the debtor has. If what we have is unable to satisfy the debt, my assumption, based on the steps that you need to take, would be that that was all that you could find in terms of your pre-action due diligence on the assets of the debtor. And if that is the case, then as the saying goes, half bread is better than none. If, however, post-action and judgment, additional assets are discovered. So for example, and I'll give you an example here, some of the agencies have access to BVN information and are beginning to use that to find assets that are under the control of some of these debtors. Those assets may not be visible by our normal due diligence as lawyers, because you will check the land registry, you may not find property in their name. You check with the banks, and the banks will give you the account numbers in their name, but not account numbers in other people's names or other companies' names that they are signatory to. And so we're limited in that regard. And if you're in a position where one of those agencies that can utilize this method is able to get hold of additional information, then you can approach the court to have those additional assets also utilized to satisfy the debt. That's.
Thank you very much, Leonard Silk.
Yes.
The questions are plenty, but I think at some point we'd have to draw the curtain. Nwosu here says, good day, Ma. Thank you for such a very insightful teaching. My question is the 6-year statute bar limited to companies, or does it include individual debtors too?
It's not limited to companies. So that Limitation Act is not for corporate entities alone.
Okay, so an anonymous attendee here asks whether recovery of taxes from debtors can be classified as debt recovery, properly so called. I don't know if the answer is in the question.
Of what?
Recovery of taxes from debtors. I mean, you're calling them debtors already, but he's asking whether it's debt recovery, properly so called.
Well, yes.
He actually referred to them as debtors.
Yes. So, yes is the simple answer.
So Al Hassan asks, where the assets of a company fail to satisfy a debt, can we have resort to assets of the directors?
Al Hassan, it depends on the underlying agreement, because, for instance, if it's most of the banks will extract a personal guarantee from the directors, in addition to the collateral from the company and so on. And if that's the case, and they have a personal guarantee, then it goes beyond the corporate assets to your personal assets as a director. If, however, you haven't given a personal guarantee, then the company is a juristic person, separate from the director, and therefore you cannot pursue the director for the debt of the company, which is a separate juristic person.
Thank you, Leonard Silk. Another anonymous attendee is asking, can creditors' claim be statute barred if the creditor does not sue within the required period because parties were negotiating and the debtor did not deny the debt?
In that case, it's not statute barred, because you are, how do you say? It becomes statute barred when you do nothing about it for 6 years. But if there's an ongoing negotiation and an admission of the debt, then it's not, the time doesn't even begin to run yet.
Okay, I think Al Hassan is satisfied with his feedback. He says, I am fully satisfied with the Leonard Silk's response. Thank you, Ma. And then someone asks, can a creditor's claim be statute barred? Okay, I think that's the one the Leonard Silk just addressed. So Anonymous here asks, dear Leonard Silk, please in drafting an engagement letter for debt recovery, is it advisable to include judgment enforcement terms and procedures in the letter? Thanks for the session.
It's advisable because that's why I talked about the scope of work. And I deliberately stayed away from defining that scope of work because it could be a trap. You think that's all there is to it. Each set of facts requires different actions. And therefore, if the facts before you require you to carry out those steps, having looked at those facts and decided your strategy, then you include it in your scope of work and include it in the costing and the fee that you're charging your client.
Thank you, Len Silk. Oluwatobi asks, is it correct that accruing interest translates to continuing course of action such that a debt to the bank cannot be statute barred because interest accrues daily?
That is, again, subject to the agreement or the terms of the specific contract between the bank and its customer. We know that the banks will go for an arm and a leg, and like I said, your grandmother's death certificate and so on. So it really depends.
All right, so another anonymous attendee asks, assuming a creditor reported a debt scenario to a law enforcement agency and the parties are called for settlement, which eventually fails, does this settlement event count as notice to the debtor in case the creditor wants to approach the court?
You know, this practice, which happens in this jurisdiction, is, to my mind, not something to be encouraged. It's part of why the law enforcement agencies are disrespecting us as legal practitioners. They are encroaching in our space. Because really, why are they debt collecting and why are they calling debtors and creditors for settlement meetings? It's not their, it's not part of their work. It's not what they're supposed to be doing. And they should, when such reports are brought to them, please go to your lawyers and take your matter to court. That should be the proper response. Ultimately, the only time they get involved is if there's a threat of the breach of the peace or if there's been some criminal allegation related to the transaction. And you would see that in my presentation, I talked about the fact that they actually manufacture this in order to put it within the jurisdiction of these law enforcement agencies. So in practice, I would prefer to send out my pre-action notice as promptly done, rather than relying on a police report or police intervention.
Thank you very much, Leonard. I think we should pause and take some commendations. Light AC here says, thank you, Leonard Silk, for your riveting and insightful lecture. It cleared a lot of my concerns in the debt recovery space and reinforces my confidence as a lawyer, especially in the in-house space. And Latifat Asipita says, thank you, Leonard Silk, for simplifying it with scenarios. Kenechukwu Chibueze says, thank you, Leonard Silk, for this in-depth lecture. And please, I want to appeal to colleagues to post your questions using the Q&A tab, so it'd be very easy to retrieve the questions. Adedamola Lapite says, good afternoon, great session ongoing. Karen Nkechi Ojo says, thank you, Leonard Sook, for this brilliant and insightful lecture. I mean, there are loads and loads of commendation. Patricia Adeyanyu, sorry for murdering your name, says, thank you, Leonard Sook, for the simplified way the lecture was taken. Joshua Babade says, thank you, Leonard Sook. There are loads of commendations here, and apologies if I cannot fake yours. Rafael Asadu says, thank you, Leonard Sook. That was brilliant and insightful. Ozioma Oyenweke says, thank you very much, Leonard Sook, for this superb lecture. God bless you. And I say a very big amen to that. Deborah Obiyo says that you missed the beginning part, so the presentations will be made available. Alake Adebayo says, thanks, Leonard Sook, for a very good, refreshing lecture. You're welcome, Alake. So I think we'll just take very few questions before we call it a day. Oluwatosin Koka says, please, what happens when the debt is statute bad, but the debtor admits to the indebtedness upon demand?
Well, this is where we would use other tools, because if we went down the traditional route of just let's go to court, that could be a defense, the fact that it's statute barred. So if the debtor admits, then we can begin to look at alternative methods of collecting that debt. That would go back to my what I talked about for acting for the debtor, although you're acting for the creditor in this case, but it's literally effectively almost like a mediatory role. Let me know what you can pay, give me a realistic, workable payment plan, and stick to it.
Thank you very much, madam. Okay, so I guess this is a reaction to what Leonard Sook said earlier about involving law enforcement agencies in debt recovery. So Aisha Salami says, what would you advise where a debtor issues post-dated checks as collateral, and at the due date, the checks are returned dud? Should criminal action be taken against such debtor alongside debt recovery procedure?
Absolutely, Aisha, because that is a clear-cut, what's the word I'm looking for? It's clear-cut. So you have issued checks, the checks have due date for presentation have come, and they're done checks. So it's a strict liability offense, so to speak. All I have to show is that this check was issued, it's your signature, and the check bounced. Strict liability offense. You would bring in the law enforcement agencies in addition to your debt recovery. It would be added pressure.
Thank you, Leonard Sook. Mr. Dambeki Patience asks, okay, well, this is commendation. Thank you, Leonard Sook. Such an educative and enlightening session. He's asked for the copy. Of course, we'll make copies available of the presentation. Chidi asks, assuming there is no personal guarantee from directors of a company, at what point and how will the veil of incorporation be lifted?
You would have to give a very good reason for the veil of incorporation to be lifted, because there's a reason things are structured the way they are, that the entity is a juristic person separate in its own right from the directors. And in order to achieve that objective of showing, of lifting the veil of incorporation, you then have to adduce sufficient evidence to show that they are really one and the same, and the directors got the benefit as opposed to the company and so many other things. It's not an easy task, in a nutshell.
So I think in the next 5 minutes, we should wrap this off. And we've taken a lot of questions already. And it would be most unfair to keep Leonard Silk for another 30 minutes in order to hit the hour mark. So there's a question here, dear Leonard Silk, please, in an action for summary judgment, is it right for the claimant or creditors counsel to claim for solicitor's fees? Please note that parties have no agreement to that effect. Thanks so much, Ma.
Well, I am a strong advocate for what happens in other jurisdictions because it will help us here, in my considered opinion. And that is, if you lose, you pay both your legal fees and the legal fees on the other side. Why am I in support of that? Because it will stop us from taking frivolous cases to court. So even though there is no agreement as to fees, the expectation would be that the losing party should pay something towards the fees of the winning party.
Thank you, Leonard Silk. An interesting one here by Martins Akarikwe. He says, please, can part payment of a debt be regarded as admission of the debt, even when repayment did not indicate what the repayment is for?
Yes, is the simple answer. Because that's the evidence you can adduce to show that, look, he made a partial payment and this was towards the debt. Whether it's indicated or not, it can serve as evidence.
So Deborah Famoi asks, in a case where an agreement contains an arbitration clause, can parties still proceed to litigation first? Thank you.
Deborah, I would advise against it, because if you're acting for the claimant and you proceed to litigation, my defense would simply be the arbitration clause. We have an arbitration clause, we are supposed to go to arbitration, we're not supposed to be here, and it's likely to be upheld.
Thank you very much, Lensig. I think it's a convenient place to draw the curtain, but there are still more commendations flooding in. We have from Blessing Agawebe, who says, awesome presentation, thank you so much. We have Safatiga says, very insightful, thank you so much for this. Lorita says, thank you, Ma, for this insightful lecture. Ibrahim Suleiman says, this is very insightful, NSO, thank you. We urge that these slides be made available. Of course, they will. Sumbo Iyange says, thank you, Leonard Silk, for this very insightful lecture. Okay, I can't go on and on. I mean, there has to be an end, like an end to litigation. I don't know if the chair of NBICLE, Tobena Erojikwe, is still online. I would have wanted him to specially thank Leonard Silk. Tobena, are you still online? Okay, I don't think he's here, but Leonard Silk, I want to, on behalf of the chairman, NBICLE, Tobena Erojikwe, I want to thank you immensely for your time. Thank you for the very insightful and excellent presentation. You can see, the comments coming in, the questions are still flooding in, but unfortunately, we can't do this till 4 because Leonard Silk obviously has other pressing engagements. But Madam, we want to thank you so very much for finding time out of your very busy schedule, to join us for this session. You've spent more than, about 2 hours with us because you joined about 30 minutes before the session officially commenced, which makes it about 2 hours. And that's why I say it'd be most unfair to keep you here till 4 o'clock. So thank you very much, Madam. Thank you so much. And we hope that when we knock on your door on future occasions, you would always open up and then share with us from your wealth of knowledge. So we thank you so much, and we cannot thank you enough. Thank you. madam.
Thank you for the opportunity, and thank you to the very interactive audience of colleagues. It's been a privilege.
Okay, so ladies and gentlemen, thank you so much for your patience, and thank you for joining us. Don't forget to join us tomorrow by 2 p.m. We'll be having Mrs. Abimbola Akeredolu, Senior Advocate of Nigeria, join us, and she'll be dealing with the topic, Debt Recovery Litigation, Practical Guide to Effective Use and Challenge of Injunctions and Freezing Orders. 2 o'clock Nigerian time, 2 o'clock West African time tomorrow. Please do join us. So once again, thank you very much for your patience. Thank you for your contributions and participation, and see you tomorrow. Have a good day. Cheers.